That's a great question because there is a lot of anxiety sometimes with people who come to lawyers and they say, well, if I file a lawsuit, does that mean I have to go to trial? I always tell individuals that we prepare your case like it's going to go to trial, okay? Because that is, for one, the only way that a defendant takes you serious or believes that you're going to take this case to where it needs to be taken. And so the only way that you get the compensation that you believe your client deserves is to prepare this case as if it's going to trial. Because if they don't think you're ever going to try this case, they will never put their best offer on the table. With that being said, I tell individuals all the time, 95% of these cases get resolved at some point in the litigation process without going to trial. That could mean it gets settled 6 weeks in. That also means it could get settled the Friday before the Monday trial, because the more pressure is on both parties, especially with a trial date looming, everybody looks at each other and says, is there really not something we can come to an agreement on, rather than letting six strangers who don't know anything about this product, who don't understand or aren't experts in the law, to essentially judge this case. So there's a lot of that happens either formally at mediation or in settlement conferences in federal court, or after that or before that. There's many times clients after a mediation will look at me and very dejected and say, so I guess we're going to trial. And I said, well, I am preparing like we are, but that doesn't necessarily mean we are. That doesn't mean that a week from trial, I don't get a call from defense attorney that's representing the manufacturer of the product that says, hey, do you think maybe we can bridge this gap? That happens all the time. So I tell people, even though you file suit, even if it doesn't get done at a mediation, that does not necessarily foreclose all possibility of it being resolved.